Well, good afternoon, everyone. Texas A&M is pleased to be participating today in the SEC Sports Law Conversation Series. My name is Meg Penrose. I'm going to be the moderator today for what we believe will be a fantastic conversation about name, image, and likeness, and other issues dealing with the modern NCAA. This is a legal discussion. This is not a period for legal advice. So hopefully you're here just to learn a little bit about our ideas from an academic perspective, and then some more close to the experience of how the NCAA's new constitution and the Supreme Court's case involving name, image, and likeness has changed the landscape. I'm going to introduce our speakers for today's event. I come up first because I'm your moderator. I'm a former Division I scholarship athlete in women's basketball. I'm a member of the Texas A&M Faculty Athletics Council, and I'm the incoming chair of the ALS section on lawn sports. Now, you can find any of our bios with a link in the chat. If you want to follow up, we will remain available to you for questions after today's program. Next up, I'd like to introduce my colleague at the law school, Professor Neal Newman. Neal is a former Division I All-American track athlete from the University of Michigan. Here at the law school, Neal is an award-winning law professor, and he teaches business-related classes. His most recent scholarly article is entitled, "Let's Get Serious, The Clear Case for Compensating the Student Athlete, a University of Michigan Athletic Program Case Study." Our other speaker is Professor Paul Bautista. Like Neal, Paul is a former Division I scholarship athlete, having played baseball at Trinity University. Paul teaches on our main campus in the sports management program. In addition, Paul is our faculty athletics representative and has been so for several years, since 2016. And he is a member of our faculty athletics council. When Paul begins talking, we're going to have him introduce what these concepts are, the faculty athletic representative position, and then a little bit about the Faculty Athletics Council. Our hope today is to host an engaging and somewhat informal session. To help with that, I would ask that if you have questions during the presentation, you either post your question into the chat or you raise your hand. I will be keeping the queue. And with that, I'm going to turn things over to my colleague, Professor Neal Newman. Neal.
Thanks, Meg. Appreciate that, and appreciate all you all out there in Zoom land. Very excited to have you all joining us for this talk. We didn't get a demographic, but you're either someone who's studying this issue. You may be in sports in some capacity, or you may just be a sports fan. But for all you all, welcome. Glad you all could join us today. So as Meg kind of pointed out, we're going to be talking about two broad topics: the name, image, and likeness, and the Constitution. But broadly speaking, this is somewhat of a speculative exercise. As you all know, a lot is going on with the NCAA and name, image, and likeness. And we thought it would be interesting to sort of get speculative in what we think is going to be happening with these issues down the road. So without further ado, just our agenda is, first, we're going to give a quick NIL overview, but very quick. And then we're going to get into a case study. And I've chose this case study because I think this was very significant. And I think it's going to a foreshadowing, if you will, of the form that NIL will take in large part, but that remains to be seen. Then I'm going to talk about some key takeaways, and then I'll be handing it over to our colleague, Paul, who will talk about some unintended consequences of all that is shaking out. And we hope when we get through all that is just to have robust discussion from our audience and you all weighing in and giving your thoughts and insights. So that's our plan. Action-packed and fun-filled, we hope. So how we got here, very quickly, and there's a really much longer history, but recently this summer, the Supreme Court made a ruling in NCAA versus Shawnee Austin et al. And that is just having reverberating effects. The net effect of that is the NCAA can no longer put limits on the educational benefits that schools can provide to their student athletes. And so what that decision has done is essentially opened the door and not exactly eliminate caps, but just make it a very wide open exercise as to the form and contours of benefits that can be provided to student athletes. So that's essentially how we got here in a one slide nutshell. What's happening now is very interesting. So what this chart shows is, as of June 2021, and there may have been some changes since then, as you see in the red are all the bills that have currently been passed. A lot of them are SEC and Power 5 schools, I might add and throw in there. So it's color-coded, bills waiting for governor's signature in purple, no bills introduced in white. So all this is interesting how this is playing out. So what I wanted to focus on, you all, was the state of Utah and what happened in Utah in late summer of 2021 that I think is and will be a reverberating effect on the shape that NIL will take. So what happened in Utah, we've got this school, Brigham Young University, a fairly solid football program school. They finished 10-3 last year, and they finished the season ranked 19th. So they are a player, if you will. And what they did is they have partnered, the school and the football team has partnered with a protein bar brand called Built Brands, who's based out of Utah. And what they did with that is that they provided tuition for all BYU walk-ons in exchange for the football team promoting the Built brand. And this happened in August 2021. So very shortly after that Supreme Court case, and very shortly after a lot of states finalized and passed their NIL legislation. So the timing is important to appreciate. And just a story behind that, this is Nick Greer. He's the CEO of Built Brands. And this is him giving the news to some of the walk-on athletes that their tuition is now going to be paid for. And of course, Built Brand bars are stacking the locker room, if you will. This right here is Nick Talmadge. He was a walk-on older student who has a family. Before this, he was paying tuition during the off. He was working in the off season in order to get enough money to pay tuition and help out with the family bills. So this was indeed a game changer for him, and I'm sure many of the walk-ons who are now having their tuition paid for. So this is Nick Greer, and the press conference he gave, he said some interesting things. Nick Greer explained that part of his vision was to help move NIL discussions and opportunity towards a team focus and away from individual athletes from I to we. What's interesting about this is when we were moving into this NIL, it seemed like the model that was perceived or expected was that athletes would go on their own, if you will, and try and kind of navigate this NIL sort of separate and apart from the schools. But BYU looked at it a little bit differently, and they took this approach, right? So this is Gary Verone. He's the director of compliance at BYU. And again, what's interesting is he started working on this about 18 months prior to the June 21st or July 2021, when a lot of these bills were passed and put in place. And what was also interesting was when he did this, he got a lot of calls from a lot of schools, and they asked him, how was this legal? How are you doing this? How are you able to do this? And this is where it gets really interesting, at least in my book. Well, how they were able to do this was because, as you all know, BYU is in the state of Utah. And as we pointed out, BYU, or the state of Utah, had no NIL bill. Most of these NIL bills currently have restrictions in them that prohibit the schools from assisting or being involved with the athletes' NIL efforts. Well, because Utah had no such restriction, they were not limited in the schools partnering with the with the third parties the student athletes. So that has created a situation where, so the reverberating effect here is, in my estimation, is that prospective student athletes are going to be looking at the schools and asking, what is your program? What is your protocol? What is your intention to assist athletes in moving forward with name, image, and likeness efforts? In my mind, this was a game changer. And to that effect, what has already happened, and Paul pointed this out to me in our pre-production meeting, if we can call it so fancy, Florida is now amending its NIL bill that was already passed, and they're lifting the school restriction. And that's no surprise. Alabama, all right, and we know what football schools are in Alabama, they just said scrap it, and they have repealed their NIL bill. So this is already having a reverberating effect on the landscape, the legal landscape. And, we've already gotten past this recruiting season, but I'm very certain that going on in conversations in living rooms going forward is, what is your plan and thinking for NIL? And I think that has changed. BYU taking this approach has changed the game, if you will, or has changed the trajectory at the very least. So as I just wind down on my portion, and I'm about to pass it over to Paul. So key takeaways from my viewpoint is state laws. I expect them to lean towards less versus more restrictions. I expect to see schools collaborating with athletes versus athletes taking this path alone. And what will be interesting, and Paul may get into more of this, where the NCAA fits in all this. In my mind, they had a chance to get ahead of this. They resisted compensating athletes kicking and screaming. And so now they find themselves in an unenviable position of trying to play catch up and trying to get their footing. Congress, people are looking at Congress. If you study politics, you know how preoccupied they are. You know what's going on there. So I just don't know how much of a priority this will be. So I don't know how much will get done in that regard. So for the time being, I think this is going to be sorting itself out without any sort of input from Congress. So with that, I'm going to pass it over to Paul. Paul, I'll let you take it away and give your thoughts and insights.
And Paul, as you get started, if you could explain to those that are listening today a little bit about what a faculty athletic representative is and does, and then the faculty athletic council, that'd be fantastic.
Thanks, Meg. And Neal, thank you for inviting me to do this. This is what I deal with on a day-to-day basis. So the NCAA establishes in the Constitution and in the new Constitution that every institution must have a faculty athletics representative. It is an appointed position by the president or chancellor of the university, and we'll refer to it by the acronym FAR. The FAR reports directly to the president or chancellor of the university and is completely independent of the athletic department. There are 3 or 4 main things that FARs do. The first is to provide oversight of the athletic department. So my job is to make sure that they're doing things the way that they should do. To provide institutional control that we're complying with the rules and the regulations of the SEC and the NCAA. The second thing that we do is I am the representative or the liaison, I guess you could say, to the SEC and the NCAA. So that's my second position or second task. And then finally, and to me most importantly, it is my job to make sure that the athletes on campus are getting appropriate experiences in both academics and in athletics. Meg mentioned Faculty Athletics Council. She is on our Faculty Athletics Council, and that is a group of people, primarily faculty members, that also provide oversight and report to the president. It also includes people from the athletic department. Our athletic director is on that. Our senior women's administrator and others, compliance officer, are also on the Faculty Athletics Council. So in reality, what I am is I'm a boots on the ground guy. And Neal has gone through these NIL things, and the law professors on here are always interested in what the law is. For me, I'm more interested in what's going to happen with all of this. And I'll start out with one of the ironies of all ironies. California passed the first NIL law in 2018 or 2019, and they set the implementation date of July 1st, 2024, I believe is the correct date, to give it some time to mature and see how it should be run. Well, as soon as they did, oh my gosh, every major football institution, all the A5 says, oh gosh, we're not ever going to be able to recruit athletes here. They're all going to go to California. We need to pass one of these as well. And they did. And now Florida's not happy with theirs, and Alabama's gotten rid of theirs. And many states, it was sort of haphazard. I will tell the story about the state Senate here in Texas when they had a hearing on whether to move forward with the NIL law. One of the state senators that was on that committee is a friend of mine, and the chair of that committee started the hearing by saying this: there will be no NIL law in Texas that has any punishment penalties contained within the law. So Texas has passed an NIL law that has absolutely zero provisions for punishment or if you violate the law. We've all read a lot of statutes in our professional career. I've always read them where they say, thou shalt not. And if thou doest, then here's what's going to happen to you. But the strange thing is, there's no provisions for that in the Texas law. I just came out of my undergrad class talking about this earlier this morning, and several of the students afterwards kept asking questions. Well, what happens if this happens? It clearly violates the law. It says you can't use it for recruiting. Well, we know that they are. And I told them, I don't know, because there's absolutely no punishment provisions in there. So I guess as time moves forward, we'll see what happens with that. Nonetheless, when Meg called me to ask some questions about this, she and I got into a conversation about NIL and the new Constitution and the Alston case, and started talking about the ramifications of this. And we had a conversation about some of the unintended consequences of this. And that's what really interests me, because in a lot of respects, I'm dealing with those every day, or at least trying to think and be ahead of what might happen and how we might do something about it. Some of when people ask me, what's going to come of this NIL? What do you think is going to happen? And I kind of chuckle and say, well, here's what we need to be doing. We need to be taking bets on who's going to be the first former college athlete who's going to be in his NBA practice or his NFL practice, and the IRS and the FBI is going to show up and put him in handcuffs because he hadn't filed a tax return on his NIL earnings, and he hadn't paid taxes on what he's earned. And you know it's going to happen. You know some of them are going to take the money and think, oh, great, I'm finally getting what I deserve. Or they get the money for the first year, they get hurt, or they drop out of school, or they don't get their NIL renewed, and they've spent the money, they've gone out and taken that $75,000 or $100,000 and bought a brand new BMW, and they have no money left to pay their taxes. So that's the first thing that jumps out to me. We have seen, so one of the things in the Texas law is before an athlete can sign a contract for NIL, they have to submit it 10 days in advance to the compliance office on campus. We have seen some of these contracts that not only talk about NIL during their playing career in college, but had provisions that the people that were putting up the money had lifetime rights to these athletes' name, images, and likenesses. Obviously, we told them, don't sign this, but there is no provision to certify who can become an NIL agent, if I can use that term. So there are so many things that I just worry about. We all think about the amount of money that's being paid. By the way, if you read or saw the thing about A&M using $30 million to recruit football players this year, that's not true. I wanted to get that in there to make sure that I didn't get accosted for not clarifying that. But just this week, a group that's going to fund NIL at the University of Tennessee has said their goal is to create $25 million per year in NIL payments to their football players on campus. $25 million, that's a lot. So I don't know what's going to happen with this, but it's a little bit scary. So I'm going to take a pause for just a second and see if anybody has a question.
Paul, I had a question. I was listening to your sort of the things you're seeing going forward, and you mentioned the IRS situation. What role, if any, do you think, and like you said, we're getting into very murky and unprecedented territory, what you're thinking about the school's roles in trying to help the student athletes navigate these issues like IRS compliance and filing tax returns and things along those lines? What roles do you think the school should have with that, if any?
Unlike Utah, Texas NIL statute says that the schools can't be involved in the securing NIL deals. What the Texas law does do is require every athlete to take a 5-hour financial training in their first and third years on campus. We have a very rigorous one. That's well and good. You can lead a horse to water, but you can't make them drink. And my concern is that even though we're training them and telling them you have to file a tax return, some of them just, I don't think will do it. And a lot of the athletes come from backgrounds where maybe they don't have anybody that can advise them. And I have found on occasion that some of them are almost embarrassed to ask questions because they feel like they should know those things. And it makes them feel not very smart if they're asking questions they think they should know. That's our job to try to teach them. And those that want to do it the right way, they're going to be fine. They'll be okay. But there's always going to be those that are just not going to do what they're supposed to do. They don't come to class when they're supposed to. They don't turn their assignments in on time, and they're not going to file a tax return.
Excellent. So we've got a couple of questions in the queue, and I'm going to start with my colleague, Tan Boston. She's also a member of the ALS Executive Committee for the Law and Sports section. So Tan, go ahead with your question, please.
Good morning. Thank you. One question that I have for you, Paul, you know how the NIL collectives are forming at all of the various Power 5 institutions. What do you see their role in helping the athletes kind of navigate these tax issues? Because I've been reading about some of the collectives are setting up the LLCs and handling the business aspects of that, but I don't really know, the details of it. So if you have any thoughts on that or any insight, I'd be interested in hearing.
I would hope that everybody involved in this space is doing those things. It's to me, it's part of the obligation that they have. Somebody should be helping the athletes that they're providing funding to. I would be certain that many are and doing a good job. And there are some around that I've read about. I don't know many of them, but they are sort of a full service shop, if you will. But again, there's no certification. Anybody on this conference right now can go out and be an NIL agent and approach an athlete and say, if you'll let me do it and pay me 15%, I'll go out and get you an NIL deal. And then they take the money and run.
Thank you.
Thanks, Tan. And Riley, you noted you had the same question, but I'm hoping you also have a follow-up to that. So if you want to introduce yourself and then ask your question, please.
Yeah, I study sports management here at Texas A&M, and this is an extra credit opportunity, but I also work in NIL for a company who we sign athletes to represent our company in town. So I thought this was very interesting to come on and do. My question is, as the person who represents the company that the athletes are signing with, we have run into the issue, and it's hard for us to know the exact rules. These boys are going into and all athletes, girls too, are going into these seminars and these things about NIL and about compliance. We, as the company signing them, are not always clear on those rules and what they're hearing from the university, because it's not open to public knowledge. So while I've heard I directly am not allowed to send a contract to compliance, it's the boy or the girl that is playing the sport. It has to come directly from them. What is something that we can do to be helping these kids do the right thing on our end and on their end when, not everybody is always on the same page?
I can't talk for 1,000 other colleges in the NCAA, but we had this conversation this week. So we have apparently, some other than you, or perhaps you, have sent the word up the line that we would like to know what we can and what we can't do, and how do we go about doing these things. So I had a conversation with our senior athletic department staff about that very thing, and we're going to put together an educational course to do those exact same things, because we want you to know how you should go about doing it the right way, because that, first of all, is the right thing to do. And secondly, it protects our athletes and makes sure that they are doing things the right way and that they're not going to end up having problems in the future. So that's a great question. And I'm glad to know that there are people that are doing these things that are really interested in doing it the right way and getting the information.
Excellent. Well, we'll wait for the next question. What I might toss out to both Paul and Neal is this question about Title IX. We're at the important milestone and anniversary of Title IX this year, but I want to know, when we look at NIL, my sense is that the sports and the athletes that'll benefit the most are likely men's football and men's basketball. So in a situation like you saw at BYU or just across the athletic department, what Title IX issues, if any, should we be thinking about?
I'll let Neal start, but I need to say, I don't know this for a fact, but I keep hearing the athletes that are making the most money is a pair of twin volleyball players at, I think, Fresno State, that are literally making millions of dollars a year with their Instagram. I'm not a social media guy, so I may be saying the wrong thing, but with their Instagram. So just an aside, yes, it's going to be primarily men's football and basketball, but it's not entirely. So Neal, I'm gonna let you have it for a minute, and then I'll jump in.
Meg, I was hoping you wouldn't take us into the Title IX waters, because they're deep and murky, and I have just enough expertise to be dangerous. This is just an opinion. This just goes back to the landscape that we're in, which is kind of like, just, I won't go so far as say it's a free-for-all, but it's going to have to sort itself out. And I think right now it's just going to be a market-driven thing. So, Meg, I'm assuming when you say Title IX, you're just talking about the equality of opportunity, and whether this is going to shade more towards men's basketball and men's football, the more higher profile sports, and will they be getting the opportunity, and should that raise Title IX issues? That's tough, because just from a pure market perspective, it's kind of what's your marketability, and who wants to use your name, image, and likeness to sell the products. But then at the beginning, we did talk about how schools are partnering with companies, and it's going to be where's that partnering going to work, and are they going to be striving to be equal, or are they going to go with what they feel will give them the most bang for the buck, and where do those sports lie? So that's a long-winded professor answer saying I don't know. It's speculative. But also, to the point that Paul made, there's a lot of creative marketing out there for the sports that aren't as high profile. And there's a lot of niche marketing out there where there is big followings, I won't speak for everybody. I'm a little older. I'm not as versed in Instagram and what's all is going on in that sector of the world. But my guess is there's a lot going on. There's a lot of niche where a lot of these creative folks who are not high profile football and basketball are carving out a niche and, making some pretty good money off the name, image, and likeness. So I think it's going to have to be sorted out like everything else. But right now, I just think it's a market issue. But, that remains to be seen.
Well, and
Neal, let me
go ahead, Paul.
First of all, Neal, let me jump in. I'm not a little bit older. I'm a lot older. I'm just glad I figured out how to use Zoom. But so let's take your example of Utah. So the athletic department there went out and got the sponsorship. Clearly, in my mind, they better be doing something for the females on campus as well that's equivalent or pretty much so. I read an article earlier this week. It's crazy that every day things change. I get ready for class on Wednesday, on Tuesday night. Wednesday, something changes for my class on Thursday. So this week I saw that the Ohio State University is putting together one of these, and apparently the author of this particular article said they're the ones that are getting the most money to their football players, but it's through something that's attached to the university. So clearly, to me, Title IX would apply there. Sorry.
Yeah, I think that goes. No, it's really good to have this type of conversation. And Neal, the BYU example, as I understand it, these are students that are getting tuition, right? So that is your classic educational opportunity tied to Title IX versus what I think Paul was originally talking about, and I would presume you're talking about female volleyball players out at Fresno State. We like some athletes, not necessarily because they're the best on the pitch or on the court or on the field, but because they have a personality that stands out. But then again, we see this, at the Super Bowl this year, you had Serena Williams in a commercial with Peyton Manning, right? So you're starting to see some sports figure that have a really, really broad following. But I think when we start talking about the educational benefits, whether it's tuition or access that are given just the male athletes, that may be one of these unintended consequences. The next, and I'm looking, so I'd love for others in the audience to raise some questions. But while we're waiting for that, Paul, what about the future of athletes as maybe employees? How far are we from athletes simply becoming employees of an institution to get us outside of what's about to be this name, image, and likeness chaos?
If you have read Justice Kavanaugh's concurring opinion in the Austin case, we're really close. To me, when I read that, my first thought was he just laid out the roadmap for athletes to sue the NCAA and the universities to become employees. And there are so many things that go along with that. We've already seen the attempt to unionize players at Northwestern University. There's another lawsuit right now that's been filed. The Johnson lawsuit in Pennsylvania, the U.S. District Judge there certified it up to the Third Circuit before he even tried the case. The Seventh and Ninth Circuits have said that athletes are not employees. This is one of those things that I just don't have a crystal ball on. But the thing that bothers me is if they are employees, what type employees are they going to be? Are they going to be like traditional graduate assistants, which is, of course, the argument that they make? Well, we're just like GAs. We're performing a service for the university. And, if the graduate assistants get $1,500 a month and a tuition waiver, are the athlete's going to get that? I suspect that's not what they're looking for. And when they become employees, can they then collectively bargain? I think about this. They collectively bargain things like how many games they're going to play, how long their workouts are going to be, that they want to travel on private jets, not on commercial airlines or on buses. Here's one. So we're a bunch of employees working in concert. So we go through our warm-ups on Kyle Field before the football game, and 5 minutes before the coach says, let's go out and win, they all say, Coach, I'm not sure I want to play today, but we've all gotten together and decided if you'll pay all of us $5,000, we'll go out and play today. Otherwise, these 106,000 people that came to see the football game will just sit there and twiddle their thumbs. So to me, I go back to where Neal started. 20 years ago, I said the NCAA should be paying athletes something. Maybe not all of them. Maybe it's tied to Pell Grants. Maybe it's need-based. But as Neal said, the cat's out of the bag, and the chickens have come home to roost. Neal?
Well, I had some thoughts, but we had a question from the audience. I want to defer and let them, anyone who wants to weigh in and get their thoughts in.
Yeah, so we have a question from Madison Riggins from the University of Arkansas. Hi, Madison.
Hi, forgive me. My raise hand feature was not working, but I wanted to kind of go back and touch on some of those university-sponsored NIL deals you were talking about, because as far as the NCAA is concerned, pay for play is still illegal. So how do we think that's going to start to come into effect? Because if I'm a student athlete and I'm looking at, different schools, whether it be Oregon, Texas, BYU, and they say, oh, by the way, we have these NIL sponsored deals that our university helps to, set up for you. How is that any different than a pay for play issue where, they're basically just handing you the money to come and play for them?
Just simply, it's where the source of the money is coming from. It's not coming from the university. It's coming from a third-party vendor who's presumably paying them not to play, but for their promotional marketing. So the big dispositive is the source of the money, and the source of the money is from a third party rather than the school. That's what keeps them from crossing the tripwire of pay for play.
Yes, sir. And
Go ahead, Madison, but I want to say something else, but go ahead.
Yes, I was just going to say, to kind of add on to that, I know just going to Arkansas now, I went to Auburn for undergrad. Both of those schools have had issues where it has been a third party donor that has actually been the one to get the school in trouble for a pay for play scandal. Just using this as an example, we've had an issue with Auburn right now with one of our board trustee members. He owns a company that deals with wood. If he were to come in and set up and say, hey, look, I want to give every single student athlete $5,000, $10, however much money to come and represent my company, how is that any different than 10, 15 years ago where he was just giving them the money? Yes, you can argue that he's getting promotion for his business out of it, but at least in my eyes, it still seems to be a very similar concept.
Let me first of all say, when people say they should be getting money, a lot of them that take that point of view say, well, they were getting it all along in paper bags with chips from casinos. Now it's just above the table. And basically, on signing day earlier this month, that's what our football coach, Jimbo Fisher, said. He said, now it's just, this is the way it is, and it's above board. And that's kind of it. I would like to get back to your pay for play question, though, and take that one step further. What if the courts say that the no pay for play rule violates the Sherman Antitrust Act? I'm wondering, are there any financial deals that the NCAA can put in place that don't violate the Sherman Antitrust Act? Now, I'm certainly not an antitrust expert, but basically Judge Wilkins said that the market was the recruitable athletes. Well, maybe they're going to end up being recruitable employees. And you can think about the consequences of that going forward with, as we've talked about, unionization, collective bargaining. Maybe if they're employees, would Title IX even apply? As employees, discrimination, Title VII is employment, not Title IX. My mind just works overtime thinking about all of these things and how all of this is going to work out. It may be that we end up where the players don't even have to be students at the school. I don't think it will get that far. I would hope that the courts would say that isn't about, that's a reasonable rule that is pro-competitive under the rule of reason. But I don't know what the courts are going to do. I sort of thought that the Supreme Court would do what they did in Austin, but I really would have never thought it would be a unanimous decision.
You know, Paul, you bring up a great point. Where are we going to get to the place where we return to the very reason the NCAA was formed? Was this fear that non-affiliated students were participating in athletic teams, even though they weren't associated with the institution? Or more importantly, quite honestly, is the health and the welfare of the students, right? It was the violent nature of football that brought us the NCAA and some of these rules to oversee the health and well-being of the athletes. Before I go to Riley for a question, I do want to point out Neal has taken us all to Kyle Field, Neal Newman. So I really appreciate the background. Paul has the privilege of teaching some classes there. Neal and I are about 3 hours north up here in Fort Worth. So Riley, you have a question.
Yeah, just getting in the spirit, Meg. Just getting in the spirit.
Yeah, going back to the donor issue, like board member donor issue that was kind of brought up, going even backtracking it, I saw this play out with my own eyes, allegedly, you know, as we do. But what do you guys as a group think the rule should be for athletes who have not signed officially on that dotted line on National Signing Day? I mean, there are some deals that came out of the woodwork, and I'm like, how there is no way that was done between these 5 days since signing day, you know? So for these recruits that are coming in. So my question is, what do you guys think would be in the best interest of the school and the athlete, protecting them as well before they sign on that dotted line?
Riley, I heard somebody say a long time ago, I was born in the morning, but not yesterday morning. Of course, they're using it for recruiting. That's exactly what they're doing, despite the fact that Texas law and probably every other says you can't do it. The NCAA says you can't use it for recruiting. Do you think that's not happening when you see commits and decommits? When you read articles about UT is going to get all their offensive linemen. At one place, I heard $50,000 a year. Another, I heard $150,000 a year. You know, it's pretty easy to connect those dots. So you ask me what I would like to see happen. Maybe there should be a statute that says if you make that agreement before you sign on the dotted line, that your contract with the school is void and you would be prohibited from competing at that school. Is it still going to happen? Of course it's going to happen.
And we're obviously seeing a lot with recruiting, and I just know, like, the specific deal that I was referring to, like, the school had absolutely nothing to do with it. I know that for a fact. They probably didn't know about it. They were probably not shocked to hear about it, obviously, like I wasn't born yesterday type of thing. But, you know, Coach Fisher was not a part of that deal whatsoever, probably had no idea that it was going on, and boom, it shows up the next morning, you know? So to me, that is also kind of hurting the school as well. I guess, is that just a risk that we take, like signing these athletes, like trusting them. Okay, you're not gonna go against what we say because we're signing this 5-star quarterback out of, you know, wherever. Like, is that just the risk that we take with it? Well, maybe he does something stupid and it doesn't work out, you know?
So, Raleigh, thank you for your questions. And Paul, thanks, for addressing those. We have Will Berry, who's a sports law guru, joining us today from Ole Miss. But before I take his question, another thing I kind of want to throw out, and we may not be able to address it, is we're talking about athletes moving from place to place based on the state laws. What about coaches? What about a coach that sees one state as giving her or him a better opportunity to win because they realize maybe the athletes are going to be more viable or more likely to come to a state where less restrictions exist? So I'm just going to toss that out for now. And then Professor Berry, it's nice to see
you. Good to see you too.
Meg, can I weigh in on that? And so I'm going to say this, I don't think it's controversial, but I think what we want to appreciate is, these lawmakers, they're all, well, that may be over, but they're fans of sports. And the underlying unspoken is no one wants to be at a disadvantage for their football team or their basketball team or whatever the sport of their choosing, to be at a disadvantage to compete in this new environment. And so, Riley, to answer your question, I mean, it's not too late to go back, and Alabama's already done so. I mean, probably if I had control over the landscape, and what I would recommend is, I would repeal my law for now. And I would just kind of at this time, putting any kind of restrictions or guardrails or whatever, I just think is premature, because the cat is out of the bag. The Supreme Court has spoken. We're just in a new kind of environment now, a new mindset, a new way of looking at this. So if I had my say, I'd say, you know what, we just need to repeal this law, and let's be ethical, let's be thoughtful, but let's be creative and let's be innovative. And then I think some things will sort of take shape. And I think states will have a lot more information to craft a law that's reflective of what's going on in the marketplace. If we keep trying to do it now, to me, it's premature. And it's too new, and there's too many tentacles, too much can happen. So as we're seeing, a lot of these laws are premature, and a lot of states are backpedaling because they didn't have an appreciation of the marketplace and how this was going to play out. So I just think these need to just take a step back and let it play out. That's my thought. I know William wants to speak in, and good to see you, William. Glad you're here with us.
Sure.
Yeah.
No, Neal, I think you're right on about that. I think the question I have for you and Paul and Meg as well is, where do you see the NCAA in all this? I mean, we wouldn't have even had a Supreme Court Alston case if they didn't appeal it. And since Kavanaugh's decision, my sense is that they're almost shell-shocked in a way to say, y'all do what you want. And you even see this with the college basketball cases where we have federal indictments, and yet we still have coaches coaching that we know paid players. And so do you just see them, with the new constitution, especially just kind of holding on for dear life and creeping back in the shadows and sort of letting the market unfold? Or where do you see their role in all of this? Because to me, they pushed the amateurism narrative for so hard for so long. And now it seems like they're sort of shrinking back in a way that we haven't seen in a long time.
William, that's a great point. The word I use is eviscerated. I think that's what's happened to the NCAA. I'm not going to say they're powerless, but they certainly don't have much leverage. And you think about all the things that can happen after Alston. I was at the NCAA convention when we voted on the new constitution, and the conversation was, what do we do? What are we going to do? And some of the arguments, I thought one lady made a pertinent point. She says, every college athletic experience doesn't have to be the same. Every conference doesn't have to be the same. Every division doesn't have to be the same. Maybe it's time to break it all down and start all over and let everybody regroup into the basket that they want to be into. So from my point of view, I'm wondering if there's even going to be an NCAA in a few years down the road, to answer your question.
Yeah, and just to add, I have no sympathy for the NCAA. I was an NCAA athlete. Track was not as high profile. We didn't get into those issues. No one was trying to slip me any money under the table. But I've got no sympathy for the NCAA because, they have, they're coming in here kicking and screaming, and they tried to hold on for dear life to the old model. And when the signs were coming, as Paul mentioned, when California passed back in 2019, their bill, that was the domino that started things falling. NCAA had plenty of opportunity to get out in front of this, to control it, to try and evolve with the changing times, but they chose not to. So the states decided we're going to move forward. And really the way I see it is California made that decision. And the other states followed suit because they felt like they had no choice, because otherwise they're gonna, once you tip it one way, they all are forced with either we follow suit or we lose an edge in recruiting. And so that was all that needed to break the dam open. So I've got no sympathy for the NCAA. They had an opportunity to get out in front of this. They didn't. Now they are scrambling to find some footing in this. And they're just looking, like you said, eviscerated, Paul. That's an excellent word, because that's what it is. And they're trying to scratch and see where they come out. But they're in free fall right now. And I'm not overly sympathetic.
So
Others may be.
I'm sorry.
I'm going to use a con law analogy. I think the word amateurism, when it relates to the NCAA, has become as elastic as the necessary and proper clause. And way back when Chief Justice John Marshall, when the Constitution was first being interpreted, the question was, what is necessary? What does that word mean? And the Chief Justice in a U.S. Supreme Court opinion said necessary means convenient. And of course, most people don't think necessary means convenient. They think necessary means like you need to do something. And I think amateurism is turning that way, right? We're calling athletes with $1 million deals now under name, image, and likeness amateurs. Well, the whole point of being a pro is you're receiving compensation for your athletic ability. And so I think I'm unclear and unsure of what's going to become in the NCAA, but I probably agree with Neal and both Paul on this. It didn't come out of nowhere. I mean, it's almost their own fault and their own making, and it's quite disappointing. It's quite disappointing that, knowing the origin of the NCAA, they stood back and fought this in the court rather than working with our athletes, right? I do think the welfare of the athletes remains critical. So what are they going to be relegated to? Maybe hosting national championships, right? That may be what's left. And if that is where we are, that's probably a result of their putting their faith in Congress, because I know they kept pressing Congress, but I think most Americans look at Congress and realize they're not solving a lot of our daily problems. And so where would this rank on that? I just think it was poor strategic choices. And I think the Supreme Court stepped in truly just because there was such frustration that these athletes, the amount of money made at the NCAA level in these championship sports, and then these athletes, not as one of my friends, Paul, has said, you can't take someone out on a date on the weekend. You're working this summer to pay for tuition when the university is getting a lot of money off of your performance. And so I think we're just here as a natural consequence of the failure of the NCAA to do what they probably should have.
So, Meg, I've said for years, if you want to know what the NCAA is going to do, follow the money. And that's why we are where we are. I would like to, we're getting close to the end. I would like to bring up something that's really scary to me. And I don't know if my friend Ron Ricklock, who's also the FAR at Ole Miss, our host, is on. He's the expert in gambling, but I'm concerned about this. A gambler goes to somebody on one of the teams and says, I want to give you an NIL deal and pay you $100,000 to advertise my car dealership. Oh, by the way, there's a string to that. And most of these point shaving things, the way they found out about them is because people that had no money all of a sudden had a bunch of money in the bank. Well, now when you start looking at bank accounts, that athlete can say, no, this was above board deal. They just paid me for my NIL. And that may be way out there, but there's 500,000 NCAA athletes, and we'd like to think they're all upstanding citizens, but that there's that handful out there that are going to be looking for something. And that's one that really scares me. So I don't know if Ron's on here. Maybe he'd want to kick in if he is.
Well, we'll wait to see if Ron is on the call, if he'll jump in. Calvin Knight has a question. So Calvin, if you'll just introduce yourself and then present your question, please.
Yeah, hey, I'm a associate professor. I'm down the hall from Dr. Bautista. So I'm in the sport management program.
He's been outside making noise.
I went and was trying to rattle the door. So I think I don't really have a question as much as a comment. And I don't know that it's like, I'm not an NCAA fan, but I also wouldn't call myself an NCAA hater. So to offer another perspective on that, I don't know how fair it is to lay this all at the feet that this is an NCAA, that they weren't proactive. The NCAA does the bidding of the schools. Like, everybody had a chance to vote on this. And so to some extent, the universities bear some responsibility for why it took so long for this to get through, because the universities themselves have a financial stake. But I think that it's not necessarily fair for us to just completely say NCAA should have been more reactive. Well, we had a chance as universities to be more reactive to this and to be more proactive in this regard. And we, like Texas A&M, Alabama, California, have all the same ability to go up and say, hey, this is what we want to do, and develop that coalition. And so I think it's, to some extent, like, I get that and I have students in my office all the time yelling about the NCAA, but I also think that, the NCAA is a convenient thing to point to whenever we should also be pointing at ourselves a little bit. So that's my comment more so than a question.
It's a great point.
Yeah, that's a fair point, Calvin. And you're right. The NCAA is the collection of the schools that it represents. So it's just the tangible thing we can point to and point the finger at. And they're the ones who are, that's the body that's either pushing back or trying to fight. But no, your point is well taken.
Well, we've reached nearly our 1 hour to have this presentation. So I'm going to give both Neal and Paul an opportunity to close, but I'd like to start by saying thank you to Wilberry and Ole Miss for setting up this SEC talk. These programs have been fantastic. It always gives a thoughtful perspective, and I think sports law is an area right now that's fertile for this type of discussion. So I really appreciate the opportunity for Texas A&M to be involved. Neal and Paul, if you'll just kind of give some closing statements, that'd be fantastic.
Go ahead, Neal.
Oh, first off, audience, thank you all for joining and participating. It's an exciting time. First and foremost, I'm a sports fan. So it's just going to be fun and interesting and intriguing to see how all this plays out. So I just look forward to the next couple of years to see what shape this takes. I know Paul has expressed some concerns. There's going to be, those are what I would call growing pains. I think in the end, it's all going to be okay. There's never going to be a perfect situation, but I think this has been a long time coming, and I'm glad it's here. And I just look forward to seeing how it all shakes out.
It's going to be extremely interesting to see what happens. Will we actually end up in the Jenkins case with a free market where there are no rules? Basically, semi-professional or actually professional athletes. One of my concerns is, what about the schools that can't belly up to the bar and pay the money? Are we going to have the haves and the have-nots? Because A&M will always have the money. I think about University of Houston and Texas Tech and Baylor and TCU. Are they going to be able to compete in this system that we have now with the NIL? I'm like Neal, though. I'm an optimist, and I think it's going to work out at some point, because I think at some point cooler heads are going to prevail, and we're going to say we really need college athletics, and we need for it to be competitive and on a level playing field.
Well, thank you, guys. Thank you, everyone, for tuning in. For Paul and Neal, again, I say thank you, and we appreciate your attendance and wish everyone well. Have a great day.
All right. Thanks, Meg. Thanks, Paul. Thank you, audience. All right, everybody. Have a productive afternoon.